the proceedings according to the recognized rules of procedure, but to see that justice was done. And we refer to the case of Sheikh and others, the reference is there, where the court held that the applicants stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35, 3A to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. And we also refer to the case of multi-choice and others versus the National Prosecuting Authority. And we just want to refer the court on what is stated on page 8 of our heads, where the court referred to the case of Zukuza and others, and held that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And lastly, we refer to the case of Dlamini and others. The reference is given there where Judge Krichler in the Constitutional Court described the phrase interests of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore respectfully submit, my Lord, that the state be allowed to re-examine, sorry, there's a typing error there, to re-examine the witness on this additional photos. Well, before I sit down, I just want to mention that there's another aspect, and we just deem it appropriate maybe to bring it to the court's attention at this point so that we don't argue these matters piecemeal. There's a footage that the state is waiting for from ENCA regarding the proposition that was put by Mr. Mgomezulu to the witnesses, namely that the deceased was shot by Mr. Longo Twala, and that in the process he shot himself in the foot. There's a footage that is available, my Lord, that we want to show to the court. We have started this process since December of 2024 to obtain this footage, but there's a certain procedure that is involved. There's an agreement that was entered with the South African National Editors Forum, SANEF, in terms of which the permission of the Director of Public Prosecutions must first be sought before a subpoena can be issued against any journalist. We started this process in 2024, and the NDPP did give authorization, and Section 205 subpoena was issued for the footage. but there's been toing and froing with the legal representative of ENCA, but about 2 days ago, my lord, they undertook to furnish the state with the footage, and we also want to take Brigadier Gininda through that footage. It's a 2 minutes footage that will not take long, my lord, and we just want to include that, my lord, as part of the state's request to re-examine Brigadier Gininda on that footage. It wasn't specifically canvassed during cross-examination. It's a new matter, and we seek the court's permission to, as soon as it comes to hand, to re-examine Brigadier Gininda on that footage. As the court pleases.
Yes, if you need any response.
Thank you, Madam. I will library until the KCA. Please. The main library. I will start with the last aspect on the footage. We would request that even before that footage is made available for purposes of the proceedings, request that the state should disclose it to the defense, and I'm saying that on behalf of accused number 1 and 3, so that we can go through that footage with a view to prepare meaningfully our defense with regard to that piece of evidence. The state is well within its rights to request an indulgence from the court to open its case in an event new evidence that is relevant comes forward. That will be up to what the court will decide. This court will have a discretion in that regard. That is my submission with regard to the last aspect. On the application that has just been moved by the state, the issue indeed has been canvassed yesterday. Just to give a bit of a background, the state indicated that he indicated when he gave us the photos that he who doesn't hear me? The state indicated that it had communicated to the defense that it would want to use these photos in re-examination. That was an address from the bar. That is soon after the state had beamed a photo of that picture on the big screen, and then I stood up and I raised an objection and indicated that this would constitute new evidence. That is when the argument about the fact that there was a discussion between the state and the defense that will be canvassed in re-examination. Apparently that information was not, or that submission was not supported by the defense counsels. In an endeavor to support that submission, the state then went to what I would call an email message that was purportedly sent to the defense, he read out that message to court, and the message did not confirm what the state said, that he indicated to the defense that he wanted to raise that message, that issue in re-examination. So I'm not so sure how the issue was then resolved, but the impression that was created to me was that in any event, that picture that the state sought to lead constituted new evidence, and the state needed to bring an application or indulgence to reopen its case in order to introduce that evidence, such that it cannot be introduced.
Sorry, you're saying the state, sorry. You're submitting that the state should reopen its case.
No, I'm saying the
You
state...
never said that.
I'm saying the state should make an application, request the court's indulgence to reopen its case for the introduction of that new evidence. It cannot
The state has not closed its case. That's factually the situation now.
Yes, my lord.
Yes.
I'm talking specifically with regard to this new evidence. I'm saying the state cannot introduce this new evidence in re-examination.
Fine.
Yes. Now, the state today brings this application to be allowed to re-examine also on the basis of this new evidence. We have objected yesterday, and we indicated the basis of our objection, my lord. Now, when one looks at the heading of the state's application, it reads, "Heads re-examination of Brigadier Kininda on the additional photos of accused number 1 and number 2. Now, immediately the state concedes that this constitutes new evidence. State refers to Exhibit S. The photos that the state wants to re-examine Brigadier Kininda on are photos that are not contained in Exhibit S. When the state went through the downloads of accused number 1 as per of accused number 3 as per the allegation, there were more than 700 photos that were found in the downloads. But then the state, in the presentation of its case, then decided to identify certain photos and compiled Exhibit S, and which in its view was enough to come and present its case based on that particular evidence. The state also indicates on paragraph 3 that the reason why such evidence was not led in examination in chief was because they were able to identify further photos at the time at which I was afforded the opportunity to go and read that very big record of proceedings. They were able to identify those extra photos, and they now want to introduce them through re-examination. Our view is that is unprocedural, my lord. As much as we admit that we realize that there's nothing that is stopping the state from accusing that evidence, but that evidence cannot be introduced through re-examination. Procedurally, the state needs to finalize its re-examination, made an application to the court for the leading of this new evidence, which is to be contextualized in its case. Now, the issue with regarding to the photos, I just want to contextualize this. Based on the extracts that the state referred to, there was a point when I cross-examined Brigadier Kininda, and I took him through his affidavit, the affidavit that he brought, that he prepared for the application of the warrant of arrest against accused number 3. Now, in that affidavit, he mentioned, amongst others, that the suspect who got into the house, who had a gun in his possession, had dreadlocks, had big eyes, and had a golden teeth. Now, with that description, I then requested Brigadier Kininda to assist this court by referring to the compiled or to the prepared Exhibit S in its entirety, on all the photos that were contained in Exhibit S, and identify these traits or these marks which he alleges in his affidavit that they match accused number 3, which were the dreadlocks, the big eyes, and the golden teeth. He then started to page through Exhibit S. As he was paging through Exhibit S, he came across a photo of a person which had a golden teeth. And then he said that was accused number 3. When I took instructions from accused number 3, I'm not so sure whether I put this on record. Accused number 3 then said to me, yes, this is my younger brother or elder brother or something like that. But that was after Brigadier Kininda had said, no, this is what is being referred to in my affidavit, that this is the person who had a golden teeth. And indeed, the person who had a golden teeth in Exhibit S was there, and accused number 3 said this was my younger brother or something like that. I'm speaking under correction in terms of whether it was an elder brother or a younger brother, my lord. Now, that was basically the essence of this identification in terms of Exhibit S. Now, that was closed. These photos that the state would then want to lead this evidence on now are not part of Exhibit S, and as such were not referred to in Brigadier's evidence in chief. As such, Brigadier Kininda was not cross-examined on them because they were not part of Exhibit S. It never anticipated that at some stage in the future the state would then come and use them. We don't say, if the state says, yeah, no, we now deem them to be relevant, we want to use them. That is their discretion. But the point that you are mentioning is that Brigadier Kininda cannot, or the state cannot introduce that evidence through re-examination. As I've said, the state would have to close its case, finalize its re-examination on Brigadier Kininda, request an indulgence for the court to introduce this new evidence. That it will be outside our ambit. That will be the duty of the court with the discretion that it will have to exercise. We understand that the state's case has not been closed. That would have happened even if after the state's case was closed, my lord. All that we are saying now is that this information cannot be introduced through re-examination. It must be introduced by virtue of examination in chief, and we be afforded the opportunity to cross-examine Brigadier Kininda. Otherwise, the procedure that the state wants this court to embark upon it's very precarious, my lord. And I realize that the state says, let the court allow us to re-examine Brigadier Kininda also on this additional information. That will be wrong. We realize that the state is saying, let the court allow us to reopen our case, to reopen our examination in chief, so that we lead Brigadier Kininda on those photos. That is in the discretion of the court, my lord. Whether the reason that they've submitted or not are sufficient, it will be for the court to decide. That will be my submission.
Yes, Mr. Ramsipili.
If it may please the court, my lord. My lord, at the outset, my dilemma would be this. Advocate Baloyi says the 16 additional photos in respect of Mr. Ntanzi that he now seeks to use in re-examination of Brigadier Kininda were downloaded from the cell phone of Mr. Ntanzi. Now, the court normally says we listen to the evidence, and the evidence that I've listened to from Colonel Stein, Mr. House, is that the cell phone of accused of Mr. Ntanzi, the Samsung cell phone, was password locked or PIN code locked, and it was not analyzed. Whatever information that was downloaded in respect of Mr. Ntanzi was from his memory card. And this brings me to the point when these photos were disclosed to us by Advocate Baloyi in April. I asked him, what is the source of these photos that you now seek to introduce? And an answer was not proffered, my lord. So my starting point is from there, because now it will look like after Stein has testified, that phone was opened and further 16 photos were downloaded therefrom, and now the state seeks to use them. We don't know who the downloader was. There's no affidavit of the downloader, the date when it was downloaded, because as far as I know and I'm aware, the cell phone is password locked, my lord. That is my starting point. And the second point, my lord, and I'll concur with Advocate Muniz, is that this is new evidence. Section 166, Section 1, is very clear on re-examination. Re-examination, the purpose thereof, is to clarify points that emanate from cross-examination on matters that were raised in cross-examination. These photos, the 16 photos in respect of Mr. Ntanzi, I've never referred Brigadier Kininda or any other witness in my defense of Mr. Ntanzi to these photos. These photos, I only saw them for the first time in April, my lord. Now, my lord, my submission is that, and as Advocate Muniz has stated, my lord, the state must make a proper application whereby the downloader of the 16 photos in particular must be recalled in their application to come and give context as to the source of the photos, an affidavit be made, and he testify under oath so that we know where those photos emanate from in respect of Mr. Ntanzi. Otherwise, my lord, to seek now in re-examination to introduce those photos when we haven't tested the downloader or the analyst, that will be tantamount, my lord, I submit respectfully, to putting the cart before the horse. Brigadier Kininda cannot testify about the photos before the analyst, cannot be testify about the photos in re-examination in particular, where the analyst of that photos have never testified in chief about those photos, my lord. And further, my lord, yesterday I even said this. These photos, inclusive of Mr. Ngube, they do not form part of Exhibit S Exhibit S was only limited to about 49 pages, 49 photos or so, my lord. My memory escapes me as to the actual number of photos that were in Exhibit S. Now, further, my lord, I hear that the state intends to also lead evidence of a footage, my lord. My lord, my submission on that one is brief. We will cross that bridge when it arrives. I mean, the state says there's still toing and froing between relevant counsel on that aspect. So we'll cross that bridge when we get there. As the court insists.
Yes, Mr. Meyiwa.
My lord, yesterday afternoon, just before we closed for the business of the day, I was invited to make submission on the very same subject.
To
Make submission on the very same subject. And my lord, I'll reiterate what I said yesterday, that if the state wished to introduce this piece of evidence, there must be an application for the reopening of the state case. And if I recall very well, that is after my submission, the court even remarked, directing those remarks to the state to say that if they want to introduce this evidence, there must be an application for the reopening of the state case. So it looks like now we are going back to the very same issue that we dealt with yesterday, going in circles, no progress at all.
Okay.
Those are my submission, my lord. Thank you.
Mr. Msolo.
As the court pleases, my lord. My lord, I just got two submissions, my lord, to make. On the introduction of a new evidence, my lord. My lord, I submit that the state is supposed to bring the application for the recalling of Mr. Mabaso, who is the one who introduced the Exhibit S, my lord, which contained the photo album that is before this court. Therefore, my lord, my submission is that from the submissions made by the state, it is not clear the reason why these pictures were not presented by the same witness, which is Mr. Mabaso, at the time when he testified. Because the state is, in paragraph 3, my lord, is making submissions to say the state was in possession of these pictures at the time when Mr. Mabaso testified. But as to the reason why this information, this new evidence that they intend to introduce now was not presented, it is not included in the submissions by the state, my lord. My lord, secondly, the new evidence by law can be introduced at any stage, even during the state case or even after the defense case, but provided a proper application is made before the court, and the reasons for the failure to include such information or evidence are placed before court. Because if that is not done, my lord, it affects a right to a fair trial of an accused person, in that he had not been given an opportunity to present and to prepare and to conduct his case on the evidence that has been presented before court. If such a new evidence is presented at this stage, the right to a fair trial of an accused is automatically violated, my lord, because he has presented his case without knowing that this information, this portion of evidence will be used against him in order to prepare his defense case adequately. Thirdly, my lord, the witness who is before this court now is not the witness who presented the Exhibit S before this court. Therefore, my lord, the new evidence cannot be introduced through this witness. Even if the court can grant the state such a leave to introduce a new evidence, but it has to be introduced by Mr. Mabaso, who is the one who introduced the pictures which are contained in Exhibit S, my lord. Yeah, thank you, my lord. Those were my submissions.
Okay, any response?
Bafowethu naloku udaba
Oh, sorry.
udaba olukhona-ke manje kuwukuthi kunofakazi inhlangothi noma ithimba-ke labashushisile ngathanda likhambise ngaphambi kwenkosenkantolo-ke ufakazi obuhamba mayelana noma ufakazi ophukama phakathi-ke iy'thombe lezo-ke bakhuluma ngazo-ke ezakamsolwa wesibili-ke lapho umnumzana uNtanzi futhi nomnumzana-ke umncubeke kepha-ke ithimba labameli benu liyanqaba ekuthizeni-ke ithimba labashushisi-ke liqhamuke ngalolo daba lokho ngoba ubufakazi lo khona-ke manje uBrigadier Gininda bathi akena-ke umuntu kade adownload-ke iy'thombe lezo ngaphakathi ocingolweni noma kwamakhalekhukhwini benu-ke lapho-ke bathi umnumzana kuMabaso kade asenza-ke lo msebenzi loyo-ke futhi kwamele ukuthi kube khona-ke izizathu lapho-ke ezikhona-ke futhi noma izathu ezibekwa ngaphambili kuqala ukuthi kungani befisa ukuthi balethe kufakazi lobo futhi bathi-ke abameli benu-ke lapho-ke kumele ukuthi kube umnumzana uMabaso ukuqala okuwukuthi uyena-ke ozana le thombe lezi bese abhale ku-affidavit bese asho ukuthi kahle iy'thombe lezo zithole kuphi nendawo noma wazithola kuphi-ke ngaphambi kokuthi ufakazi uBrigadier Gininda-ke babuze-ke imibuzo ukuthi bathi akusuye oze nezithombe lezi kepha-ke akube umnumzana uMabaso ngoba kade kuye bekazile futhi uye bagcwalisa imibukiso ka-exhibit S usho ukuthi lapho-ke kade khona-ke izithombe lezo kade zikhona la ngaphambi kwenkosenkantolo njengofakazi kade bukhona-ke manje ukuthi uma ngabe ithimba-ke labashushisi lifisa ukuthi-ke lihole noma lihambe kulolo daba lokuthi ziyaqhamuka ufakazi obusha-ke kwamele ukuthi lapho-ke benzeke isicelo ngokukhethekile futhi ngokusemthethweni ngoba-ke banalo ilungelo lokuthi-ke lapho-ke benze isicelo uma ngabe icala lisahleli ngaphambi kwenkantolo noma icala uma ngabe selifike emaphethelweni-ke lapho-ke futhi banqaba-ke ukuthi njengamanje bakhulume ngakho kepha bathi lo msebenzi loyo-ke suthi isinqumo soqhamuka kwinkosi yenkantolo.
Yes, any response?
As a court, please, my lord, my colleague Dr. Sibanda is going to reply to the issues that were raised. I just want to point out one aspect, my lord, regarding the argument of Advocate Nisi.
Is that allowed, sir?
As a court, please, I'll leave it to Dr. Sibanda.
No, you are the one addressing this court.
Yes.
Now you're saying you are abdicating that position.
No.
Your colleague should take over. I'm
Yes.
asking, is that allowed?
Well, I think if there are two counsel in the case, they can address different issues
Fine.
as they
they
arise. Yes,
Right, but you address that issue first
yes. Of the
and argued it.
of section 166. Yes.
Now you're saying your learned colleague should take over. All I want to know, is it justified in terms of our law?
Well, there's as I mentioned, counsel can divide
Yes.
the work amongst themselves.
You are right.
And
But you don't leave an argument hanging in the air.
yes,
And then I continue.
yes.
You read that case, you State
Yes,
versus...
the court did refer to that, yes.
yeah,
Yes,
Hatzenbeck, he was sitting here actually.
Yes, but
Hatzenbeck, when he made that decision.
Yeah.
1975,
Yes.
I think.
Yes, but it's no problem at all, my lord.
No, it's not me, it's the law.
Yes, yes,
Anything I say, Mina, is the law. I
Yes.
don't make decisions based on
yes,
nothing.
yes.
If you could persuade me that it is allowed, we can adjourn.
Yes.
If you can persuade me that it's allowed.
We don't want
You
to
present
belabor that.
an
Yes.
argument, and then in response, you say your learned colleague should take over.
Yes,
We all know you are
yes,
in the same matter.
yes. That if my memory serves me well, that case of Eisenberg said two counsel cannot cross-examine the same witness.
Yeah.
But there's nothing that stops counsel
No.
from.
Hatzenbeck
Yes,
was a brilliant jurist. You can't shaft him because he was talking about two counsels not presenting evidence in the same matter. Being two. There were certain reasons why he did that.
yes,
And the fact that he was speaking about the presentation of a case and not the argument in terms of the law.
yes,
You can't say it's not relevant also.
yes. But
That's why I say I can adjourn, you must...
Malat, really, we don't really want to make an issue out of this.
Okay, fine.
I will address those issues. The first one is the point raised by Advocate Nisi, that the state must first conduct the re-examination of Brigadier Gininda, then thereafter make a fresh application for the reopening of or make an application to lead further evidence. I hope I understood him correctly.
Yeah,
and
that's how I understand it.
and I think that is a point that was also buttressed by Advocate Mshololo and I think the rest of council.
Yeah.
My Lord, the point is this: if one looks at section 166, it says with the leave of the court,
Yeah, it says that.
any evidence can be led. It doesn't restrict the leading of such new evidence to any specific point. So it extends to any evidence that is sought to be led. And my Lord, we want to make the point that it will really be circuitous to lead Brigadier Gininda just on certain aspects, let him to stand down and bring a fresh application that certain evidence be led. I think that would be, and we say this with the greatest of respect, that would be a waste of court's time and a waste of resources. The Constitution is clear that this we see in section 173, my Lord, that the Constitutional Court, the Supreme Court of Appeal, and the High Courts have the inherent power to protect and regulate their own process. We therefore submit, my Lord, that it will be perfectly permissible should the application be granted to lead Brigadier Gininda on these photos. We've mentioned, my Lord, in our heads that should this evidence be regarded as hearsay evidence, we will bring an application for the downloaders, namely Sergeant Mabasa and Warandov Sandlovu, to be recalled regarding the totality of the photos that were downloaded. It is indeed so, my Lord, that Exhibit S contained photos that were selected from, the totality of the photos at the request of Brigadier Gininda, just to show certain features of accused number 3, but the rest of the photos are there, and we have made them available to the defense. Colonel Hose, in his affidavit, does canvass, and this page 13 of his affidavit, that the photos were retrieved from the disk or memory card of accused number 2, and I'm really baffled by the submission of Mr. Of my colleague, Mr. Ramsepeli, that he asked us as to the source and that we couldn't finish the answer. I mean, we told him, we even, in fact, he's the one who said it's Colonel House, and I said, yes, this Colonel House. But anyway, we are the last people to want to cast aspersions. We therefore submit, my Lord, that the application ought to be granted, and we stand by those submissions, my Lord.
Yeah, but you see, Mr. Ramsipili says he doesn't even know where these photos come from.
Well,
In other words, it could have been picked up in a dustbin, as far as he's concerned.
we just want to refer the court to the proceedings of the 16th of April 2024, page 18,
Yeah.
and there's the evidence of Warrant Officer Ndlovu, the downloader of the cell phone of accused number 2, wherein he testified as follows regarding that submission by Mr. Ramsipili. Says also the cell phone has one SD card, memory card, then all 2 SIM cards and the SD card were successfully extracted with XRY forensic tool. The then cell phone itself was unsuccessfully extracted due to the fact that it had a pattern, as Mr. Ramsipili mentioned. Then he carries on at line 20. Then the results were burnt on a CD and sealed in a forensic bag. He gives the forensic bag number. Then it was kept into the safe, waiting to be collected by the investigating officer. This is the source of those photos. And we further wish to refer to the proceedings of the 23rd of May 2024, page 103.
Okay.
This is the cross-examination of Mr. Ramsipili of Mr. House, line line 7. Mr. Ramsipili says, so I'm not going to go through picture by picture. I'm just going to summarize them as we have written them in paragraph 7.31. In respect for this paragraph, that accused will tell the court that the photos depicted on pages 13, 14, 16, 17, 18, and 21, which were according to the data created, accessed, and edited on 4 January 2021, were not done by him because he did not have this device on him at the time. Then Colonel Ho says, I cannot comment. Then Mr. Ramsipili, okay. And similarly with the screenshot in terms of paragraph 7.3.2 and the newspaper article in paragraph 7.3.3, accused 1 will deny that he's the one that accessed, modified, and created those images. In summary, my lord, we're saying that there is evidence already before the court regarding the downloading of the totality of those photos, and if need be, we will call the downloaders regarding the authenticity of these photos that we want to present before the court. So, God, please.
So, if I understand the defense, you are not averse to the application to recall the evidence regarding the photos which Mr. Balui allegedly wants to introduce into the case. You are not adverse, you are just saying this is not the opportune time to do it. Am I understanding everybody like that?
My lord, certainly we cannot stop the state from leading evidence that they think it's material to their case and relevant, yes.
Is that how you understand your position? No.
That is correct, my lord. Thank you.
Yes, my lord, that is correct, but I've also raised, my lord, the issue of the reasons why that evidence was not raised before, was not introduced before, that it must be based on record. Thank you, my lord. The reasons why this evidence was not introduced by that witness when he was testifying. Thank you.
Are these people still alive?
Of course.
Ndlovu and
And Mabasa.
Mabasa, are they still alive?
Yes, of course, ma'am.
In South Africa, we die every day. So where do they live? I mean, or stations?
Yeah.
Are they in Gauteng or where?
Well, Sergeant Mabasa is in Gauteng, but Warren of St. Jove is in Mpumalanga in Middelburg. But I'm told that they can be here next week.
It can be
They can be here next week.
next week.
Yes.
Okay. Are you still going to call any other witness besides them?
No, my Lord, as we indicated that Brigadier Gininda is our last witness. We don't intend to.
No, you just told me you got
Yes,
some footage.
Yes. Well, that will, once we receive the footage, we'll obviously, as Advocate Nisi requested, we'll be giving the footage to the defense, hear what the standpoint is, and take it from there, my Lord.
Okay, fine. Then I'll accede to this application by the defense so that people can physically see the court is fair. So the application to cross-examine or re-examine Brigadier Gininda on the basis of the photographs which were encapsulated in Exhibit S, is that so? It's different, that evidence, from what the state now wants to lead. You want to lead 3 other photos, is that not so?
Yes, for accused number 3 is 3 photos and 16 photos for accused number 2.
Okay, fine. Yeah, so the court rules that you have to bring a proper application as requested by the defense. Okay.
As a court, please, my Lord.
But it would be helpful for this court to read the judgment of Klute. I don't know if you've read it, but this is the leading judgment in this type of application. S versus van der Westhuizen, 2011 to SACR 26. It's a useful judgment. This guy was sitting with the lady who used to be a colleague of mine, but she's now deceased, Snyders and Teron. S versus van der Westhuizen, 2011 to SACR 26. This judgment traces Canadian law, English law, and talks about everything a prosecutor should do and not do, and also the objections allegedly raised by defenders. Okay, so after this, what do we do?
Well, there's only one aspect that we want to re-examine Brigadier Gininda on.
Is that so?
Yes, and we'll then ask him to stand down until the process that we've referred to is
Okay,
finalized.
let's hear.
Manje inkonzo enkantolo ke bafowethu nayo ke manje ihambisana ke nabameli benu ekuthizeni ke uma ngabe ihlangothi noma ithimba ke labashushisi ke lifisa ekuthizeni liqhamukisa kofakazi obusha kuwukuthi kumele benzeke isicelo lapho ke mayelana ney'thombe lezi kaMsolo wesibili futhi nomnumzana wesithathu lapho sithi umnumzana uNtanzi futhi nomnumzana uNcubeke mayelana nodaba lwabo ley'thombe ke lezi ey'thombe ezikamnumzana lapho ke ulokuzana umncube wathi zintathu izithombe zakhe ke kepha ithombe zakamnumzana uNtanzi bethi ziyishumi nesithupha ke lezo bangathanda ukuthi ithimba labashushisi ke liqhamukise ubufakazi balo manje lithi inkasi enkantolo ke ihambisana nesicelo sabameli benu ekuthizeni ithimba labashushisi kwamele benze isicelo kahle ngokukhethekile ke uma ngabe befisa ukuqhamukisa ubufakazi obusha.
Okay.
Brigadier Gininda, in a nutshell, Your evidence amounts to the following, that after receiving a report from Mr. Absalom Zungu regarding accused number 1 and 2, that you profile them, and accused number 1 is arrested on the 30th of May, and he makes a confession as per exhibit FF.
Athi-ke manje umshushisi usho ukuthi mayelana ngemuva kokuthola ke udaba noma ureport oyithola kubaba Absalom Zungu mayelana nomsola oqala futhi nomsola wesibili ke bese ke ngemuva kwalokho ke shuthi wena ke wenza profiling yabo ke lapho ke bese umsola oqala ke yaboshwa ke lapho ke ngelanga la ke-30 zaka May ngemuva kokuthi aboshwe ke njalo ke bese yenza confession.
That is correct, my lord.
Athi yebo kunjalo.
And in that confession exhibit FF, he mentions a traditional healer, Mr. Lionel Zwane.
Bathi ngaphakathi ke confession ayenzile kula khulume khona ke ngesangoma ke lapho noma inyanga ke lapho ke umnumzana uLion Zwane athi yebo.
That is correct, my lord.
And you then trace this Mr. Zwane with the assistance of accused number 1
Bese ke nahamba ke nomcinga ke umnumzana
on the
uZwane ke
31st of May 2020.
bese ke nahamba ke nomcinga ke bese namthola ke umnumzana uZwane lapho uLion Zwane futhi uphelekezwa komsola oqala noma usizwa yena ke namthola ke ngelanga la nge-31 zaka May.
That is correct, my lord.
Athi yebo kunjalo.
And accused number 2 is also arrested, and as a result of the 2 confessions made by accused number 2, you were able to profile accused number 3, 4, and 5.
Bathi ke ngemuva kwalokho kwabese kuboshwa ke lapho komnumzana uNtanzi ngemuva ukuthi uboshwe komnumzana uNtanzi ke lapho ke bathi ngemuva ukuthi ubophe umnumzana uNtanzi ngabe wakhona ukuprofile umsola wesithathu nowesine futhi nowesihlanu.
That is correct, my lord.
Athi yebo.
And you were able to find evidence against accused number 3 up to accused number 5.
Ngabe bokhona yini ukuthola ufakazi mayana nomsola wesithathu umsola wesine futhi nomsola wesihlanu ke.
That is correct, my lord.
Athi yebo.
Inter alia, the downloads of accused number 5 that indicates the 2 calls made, the downloads of Ms. Kelly Kumalo's phone,
That is correct, my lord.
082704435, and the 2 calls that accused number 5 made to her.
That is correct, my lord, specifically on the 2nd of August 2014 and 15 October 2014, my lord.
Athi ke ngemuva kwalokho sawuthola ke uxhumana ocingweni phakathi koKheli Khumalo futhi ke nomsola wesihlanu ke bexhumana ke ocingweni ke ihlandlo ezimbili athi yebo kunjalo ke ngomnyaka ka2014.
And that the phone or the cell phone number of accused number 5 was initially deleted on the phone of Ms. Kelly Kumalo, but was eventually recovered.
That is correct, my lord.
Bathi ke inombolo zocingo zakamsola wesihlanu kade zicishiwe ngaphakathi kocingo lakaKheli Khumalo kepha ngemuva ukuthi nenze umsebenzi yona phina nabuye nazithola futhi ngaphakathi kocingo lwakhe athi yebo kunjalo.
And that the number of accused number 5 was saved as NA on the phone of Ms. Kumalo.
That is correct, my lord.
Bathi ke inombolo zocingo zakamsola wesihlanu ke lapho kade bezibhale ngo-NA nje kuphela bengabhali igama eligcwele phakathi kocingo lwakaKheli Khumalo athi yebo kunjalo.
And furthermore, that accused number 3 was arrested on the Cleveland case 1561 of 2015, and a firearm and cell phone were recovered from him during his arrest.
Bathi lapho komsola wesithathu waboshwa eboshela icala se-Cleveland le-case 156-1/2015 eboshelwa phakathi ke isibhamu ke lapho ke firearm and what?
And a cell phone.
Futhi nocingo ke lapho ke.
Yeah, yes, my lord, but the case number, I think that case number relates to the Alexander case. The case number for Cleveland is Cleveland 96/2/2015.
Yeah, sorry about that, yes.
Athi ucabanga ukuthi leke icala le case number le kade ayibizile komshushisi case number lapho ke Alexandra ke kepha ke case number se Cleveland 196/2/2015.
And that this firearm that was found during the arrest of accused number 3 in his possession is ballistically linked to the bullet point that was found on the scene as testified to by Colonel Mangena.
bathi ke sibhamlise bamthule naso ke umsolo oqala umsolo sithathu imali yaqala la lapho ke Cleveland ke usho ukuthi isibhamiso kade nenzeka noma ke inhlolo kusona ke shuthi ama ballistic report ke lapho ke futhi bathi sona sibhamisa sidubulile lapho ke ngelanga lile kade kudusula komufi ngabe kunjalo yini?
Yes, that is correct, my lord.
Athi yebo kunjalo.
Now, without the information that was furnished by accused number 2, would you have been able to identify and connect accused number 3 up to number 5?
Bathi ngaphandle nje kolwazi oluthola ke kumsola wesibili ke ngabe bongakhona yini ekuthizeni uxhumana noma uthole umsola wesithathu maqoqo somthola umsola wesithathu bese uthole kowesine futhi nowesihlanu?
No, my lord.
Ati-
It was a difficulty at that stage.
Athi cha kade kunzima ke lokho ngesikhathi leso.
And the cell phone records of accused number 3 were also obtained that showed his movement on the day in question and his communication with accused number 5.
Bathi ke lapho ke nathola ke uhamba nathola ucingo la kamsola wesithathu. Ngemuva kokuthola ucingo lomsola lwesithathu ke lapho ke nathola ukuthi bekahamba kuphi ke lapho ngezindaweni eziningi futhi nesikhathi bexhumana ngaso nomsola wesihlanu akusenjalo?
That is correct, my lord.
Athi yebo kunjalo.
And without the information that was furnished by accused number 1, would you have been able to locate Mr. Zwani, Mr. Lionel Zwani, the traditional healer?
Bathi ngaphandle kolwazi olutholile lapho ke kumnomzana ke usibiya ke ngabe bongakhona yini ekuthizeni uthola ke isangoma noma inyanga leyo ke uLion Zwane?
No, that would not have succeeded in finding the traditional healer, my lord, particularly because he did not provide the address. He only said he can identify the house as he did not recall the physical address.
Athi cha bekuzoba nzima ke lokho ngoba yena wasithatha akalazi ke kheli la lo muzi ke loyo ke kepha wasitshela nje isikhangiso somuzi bese wasithatha wasikhola sitshengisa ke loyo muzi loyo.
Thank you, my lord. Those are the only aspects we wanted to take up with the witness. We'll request that should perhaps further evidence come to light, that we'll then request that he should be recalled, my lord.
But Mr. Mnisi said he wanted to cross-examine the brigadier.
Yes.
You remember, you've forgotten.
Yes, on the aspect of Wabeni.
Yes, that's what he said.
Yes.
Are you going to do it now, sir? Or you want us to postpone?
I did not get what was happening, my lord. I was busy.
You didn't get what?
I think the court is inviting me to do something. I just did not get what is in the record.
You said you were going to do that something. I want to cross-examine the brigadier about that information when he says that Gwabeni Zungu is afraid to come and testify because he fears to be assassinated.
I will do it when you come back, my lord.
I remember all the evidence, funny enough.
I will do it when you come back.
Athi
So, what do we do? Do we postpone?
Ufakazi.
My lord, there is one thing with the court's indulgence aspect that I would also need to bring to the attention of the court in its entirety. The court would recall that I intimated a few days ago that we were to request for the recalling of Mr. Constable Zungu, and the indication was that I need to bring a formal application, my lord.
Yes.
Yes, this is their application, my lord. It's exclusively based on one point, my lord, that the court would recall that Constable
No,
Zungu...
no, I said.
Yes,
You must bring a substantive application.
yes, my lord.
Yeah, substantive application on paper
Thank you, my lord.
so that the state can respond and me also I can read it
Yes,
and go and prepare.
no, it's fine. I will.
Okay. What do we do about this inspection in local? When do we hold it? Monday?
Well, my lord, as we indicated that security arrangements need to be made
Yeah, I know
first.
that. So,
we need to communicate with correctional services and Once we've received the go-ahead from them, we can then proceed with the inspection in loco. The one possibility, my lord, that we suggested was photos, aerial photos. I'm just wondering if we shouldn't first try that route. If it doesn't work, then we can, as a last resort, try the inspection in loco.
Yes, what's your view, Mr. Mnisi?
I'm not amenable to that suggestion, my lord.
Okay.
Because with an aerial photo, I still have to apply imagination as to what is it that could be contained in this. When this point is here, what would then be here? It will also need a lot of interpretation when I go through that photo, my lord. I think the easiest way is just to go and have, it's a very, very busy kind of a situation, my lord. Thank you.
Okay. Mr. Ramsepini?
My lord, as the court places, I do support Mr. Mnisi because we should recall, my lord, that accused Mr. Sibia says it was a secluded place where he was taken to. I don't think aerial photos and the like will do justice to his version to and instruction to Advocate Mnisi.
Mr. Umalo?
My lord, I will support my colleagues' submissions. Thank you.
Mr.
My lord, inspection in loco it's a physical site visit of the crime scene of the area to be inspected.
No, what does that mean?
Sorry, my lord. In other words, my lord, I mean, if I'm saying it's a physical site visit, it means, my lord, it has to be done physically, not by way of visual pictures. Thank you.
Okay, fine. So Monday, what do we do Monday?
Well, there was a request yesterday by Advocate Mnisi. If that request is granted, my lord, we can resume them on Tuesday.
Okay. See Monday then.
Ngibeka ngomsombuluko kosebenzayo ke. Ayakithini.